Hi, I'm Marcus Thomas, Chair of Music and Performing Arts Management at the Hartt School, University of Hartford. My topic is to form a more perfect union, reconstituting the business of record labels. We see that record labels continue to be embroiled in various controversies surrounding their business practices. At this moment, several lawsuits concerning the ownership of master recordings are winding their way through the courts. Recently, we've seen multiple bills introduced both at the federal and state levels aimed at curbing certain industry practices. And several artists have taken it upon themselves to challenge contract terms by either releasing their own music outside of contract provisions or re-recording and re-releasing music because they'd been previously prevented from doing so because of restrictive contract terms. Now, because of developing technology and what I see as a potential shift in the legal landscape, in my opinion, there's no more appropriate time for record labels to consider adjusting their business models into something that is more equitable and fair, thereby creating something that will be sustainable for what is likely to become a democratized future. Now, I won't offer specifics or mechanics in terms of contract provisions and how they'll get there, but I do have several guiding principles that I'd like to offer that labels should consider as they redevelop and redesign the ecosystem between themselves, artists, and third-party licensees. I actually went back to take a look at the U.S. Constitution, at the guiding principles that were contained therein. We're all roughly familiar with it. It's considered to be one of the most significant documents in world history. And since 1787, it's been the cornerstone of American democracy. It's also served as a model for other governments around the globe. Now, the technical and logistical aspects of how the Constitution provides certain rights for the people are contained within the 7 articles and 27 amendments. But the guiding principles that inform those articles and amendments are all contained within the short preamble. And the preamble reads, "We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States." Now, at the time that this document was created, the United States was what was then the colonies, was just coming out of a revolution, and they were finding ways to reconstitute themselves into what was going to be a sustainable union and provide a security for its citizens. In my opinion, today's music business is coming out of a transformative revolution as well. It's technical, not violent, but still a revolution impacted by technology, cultural forces, recently, of course, a global pandemic, and artists coming into their own and challenging industry provisions. So record labels are faced with reconstituting themselves, in my opinion, for survival in the future. They are threatened from without because of developing technologies and social disruptions. And they will soon be threatened from within as artists explore independent methods of a fan engagement and also for monetary participation. Amazingly, however, the preamble to the U.S. Constitution can actually be applied to help labels survive if we were to follow those guiding principles. So in order to form a more perfect union, with artists that is, we'll look at the remaining guiding principles and how labels may use them to adapt and adjust their practices to create a sustainable ecosystem. Now, I'm not in any way suggesting that labels will not have a place in the future, nor am I suggesting that artists won't look to sign to labels, because at this moment, labels still control a lot of the money and the distribution, the marketing prowess, if you will, to get records out onto the grand stage. But as technology develops and as people gain access in a democratized media system, the influence of labels will continue to wane and independent artists will gain ground. Therefore, if labels would like to consider keeping their position, I think we should consider the following principles. So, in order to establish justice, for example, I think labels should abolish the practice of using or considering masters to be works made for hire. Instead, the label should look at a system where the artists own the properties and the labels have an equitable lien, if you will, in the property. Now, there are multiple reasons for this, which I'll actually discuss in just a moment. In the furtherance of establishing justice, labels should also adopt just and transparent royalty computations so artists have better trust in what's happening behind the scenes. Now, as to master recordings, I mentioned earlier there are several cases concerning ownership of recordings that are winding their way through the court. So we have Waite and et al. Versus UMG, Johansson versus Sony, and Yoakum versus Warner Brothers. Now, Dwight Yoakam recently settled his case, very recently, so that is no longer on the table. But we have multiple artists that are now challenging what is contained in almost every recording contract on the planet, is the provision that master recordings will be deemed a work made for hire. And the language states in just about every contract, somewhere near the fourth or fifth paragraph usually, all masters delivered hereunder shall be deemed works made for hire within the meaning of U.S. copyright law. And they're either deemed to be so, or else you hereby irrevocably sell, transfer, and assign all right, title, and interest to the record label. So the label is putting the artist in the position of saying these are going to be master recordings. And just in case they're not, you're giving us all the right and interest anyway. Now, we would know through legal operation that if it's not a work made for hire and therefore a transfer, the artist could go and get their masters back after a minimum of 35-year period. Well, we hit that 35-year period back in 2013, and we've seen lots of artists go back to potentially reclaim their masters. We only have a few lawsuits that are actually making their way through the courts. The vast majority of artists have settled outside of court, with some of them getting ownership of their masters and the former label retaining distribution rights, and other settlements have been non-disclosed. Now, in my opinion, and there are lots of legal scholars that would agree, I do not see how work made for hire provisions should apply to sound recordings. Number one, it's not one of the 9 categories that's listed as eligible. Labels have always used this catch-all that sound recordings are like contributions to collective works, and therefore they should be considered. But when we consider the definition of collective works in the meaning of U.S. copyright law, it applies to encyclopedias, anthologies, and other sorts of periodicals. The types of publications that will bring in different copyrightable works from multiple disparate authors, put them into one collection that might be somewhat tangentially related, or maybe on a thematic, if you will. That is not the way we would describe an album by a recording artist, where you have a singular vision of one artist that's not a compilation of all these different folks. Of course, movies and motion pictures are included in those 9 categories, but what is cited there is the fact that, number one, they're incredibly expensive to produce. Albums are too, but $1 million is not the same as 300 million. But when you think of a movie, you have lots of participants that might be involved that could claim some form of copyright. Everyone from the screenwriter to the director to the actors to the editor, perhaps, that could say, well, I have some portion of that. And there are lots of hands that could potentially be in the copyright pie. That's not always the case with music. Music is something that could be done 1 or 2 people. In rare cases, maybe 1, but maybe 2 people. So it's not as highly collaborative where you'd have this issue of multiple people claiming ownership over a master recording. Now, something else that also is prevalent when you think of music, sound recordings, and not being relatable to these contributions to collective works is the fact that not all of them are. We have lots of artists that release singles, and therefore you're not looking at a contribution to a collective work unless you are literally considering breaking down the individual components that go into the single itself. But otherwise, that single is not a contribution to a collective work in the way that we would think of it. So work for hire provisions largely would seem inapplicable on those terms. The biggest thing to me, however, unlike all of the other things that you consider a work for hire to be, whether it's test material, atlas, motion pictures, unlike all the other things that we would consider to be a work for hire, in the case of sound recordings, in virtually every recording contract you'll read, the artist pays for the masters. The artist recoups at their net rate and pays for the master. Now, not all artists recoup, not all projects recoup, but nonetheless, it is on the artist to pay for those masters. So they're in effect paying for something that they'll never own. This is very much unlike any of the other categories of work for hire that we'd ever consider. For those reasons, I just don't think that work for hire provisions will apply. Now, that's not my determination. There are cases that are now in the courts, and the courts will have a say in this. There are several legal scholars that believe this could even work its way all the way up to the Supreme Court of the United States. I, for one, don't believe that the sound recording should be works for hire. However, perhaps the artist has the ownership as work for hire, and the record labels have an equitable lien. The record labels have a lien where they can recoup their costs. But I also think that should be at a justifiable rate, not necessarily the artist's net rate. I don't have numbers as to what that should be, but recouping off of the artist $1 versus the label pulling in 6 or 7 isn't exactly equitable. But the label should have a lien until the artist recoups, and at that point, the artist should have ownership of the master, and the label has some participation going forward. Would be, in my mind, that would be the most equitable situation. Now, also, because we have new distribution methods that allow for unfiltered data collection, that allow for direct payments, labels need to move toward more just and transparent royalty computations. The artists can do this on their own if they're going independent, and therefore they don't have a mistrust of the system. So if labels want to foster trust, they should move toward a more transparency in their accounting methods, and something that is, again, I would say would be more simplified. So number 2, again from the preamble of the U.S. Constitution, ensure domestic tranquility. So what is this peace between the label and the artist, and how do we do it? I think it starts at the formation. I'm in favor of plain language contracts, and you heard that right. I'm a lawyer, and I'm in favor of plain language contracts. I'm in favor of a contract that any artist, any person getting into it should be able to pick it up, read it, and roughly understand what they're getting themselves into. This is no different than if you have an apartment lease. The vast majority of leases are constructed in such a way that a tenant could read it and, for the most part, understand what they're getting into. Now, I'm in no way suggesting that the artist should be able to read it to the point where they go into a negotiation without counsel. No, that's not the suggestion. But the artist should be able to read it, understand it, and then have counsel to explain to them how all the various components of the agreement connect to one another to create the understanding that they'll have, and therefore the confines of the relationship they'll have with the record label. This plain language contract will go a long way to fostering trust. So the artist doesn't feel that they don't know what the label's trying to do, and every time they want to get an answer, they got to go pay a few $100 to get the lawyer to explain it to them. Nothing creates more mistrust than that sort of shell game of legalese. The label should strive to create more equitable partnerships, flatten out the royalty structure. And again, I'm not providing a specific rate, so I won't go as far as saying, oh, it should be 50-50, although that sounds really nice on behalf of the artist, but it should be more equitable, and not just the royalty rate, but again, when we think of recouping strategy, that the artist is forced to recoup on their net rate while everyone else is actually being enriched is vastly inequitable. And so that should be reviewed at some point to bring that into alignment, I think. We've seen recently Taylor Swift re-record her albums and start to release them. One, in response to the fact that she did not get the opportunity to buy her masters. This probably never would have come up had she been able to buy the masters back from Big Machine or get them from Scooter Braun. But since she was not able to do so, we've seen her start to re-record several of her masters. And in all honesty, from an artistic or technical perspective, they're pretty good. They're spot on. So what does this present to the labels? Well, as artists increasingly have the technology and the ability to re-record and get a recording that pretty much is identical or indiscernible from the original, artists will increasingly look to just re-record when they're out of their restrictions. Now, when Taylor re-released her first record, every one of us thought, okay, labels are going to figure something out here. They're going to make an adjustment. In the history of record labels, every time an artist has, quote unquote, outsmarted them, the labels have adjusted. I thought maybe it would be a good opportunity for them to just revisit the practice, but we've heard from some labels that they've actually increased the amount of time of the re-record restriction from 5 years to 7 years. I think that's 2 years in the wrong direction. Again, you're not building trust with the artist to just make the contracts even more restrictive. You're giving the artist more reasons to not ever want to deal with a record label. At this moment, the California Fair Act is being considered out in California, and it's challenging the 7-year limitation. So personal services contracts are not allowed to go beyond 7 years, but there was a carve-out or an exclusion for record label contracts, which inevitably go beyond 7 years because of the way that they're structured on album terms as opposed to calendar years. If that is successful, if that bill successfully passes, with current industry practices, that would mean labels normally would not get more than 3 albums at most out of many artists, maybe 2, unless you have someone who's really prolific, who's in the studio every year. So if that shifts the legal landscape, labels will have to start to adjust their business model anyway. So maybe this is a good time to get ahead of that. I also have some consideration about 360 deals. And here I may vary a little bit from a lot of people. Lots of people look at 360 deals and just scream that they're the worst thing ever. I'm actually not that harsh on a 360 deal. After all, when you consider record royalties, publishing, merch, touring, there's no publishing, merch, or touring if the record royalties didn't happen in the first place. It's because of the record label's duties, responsibilities, and their success that all these other forms of income are made available. That's just the reality of it. Now, for major labels, maybe the 360 deal is newer. Indie labels have been doing this sort of model for a much longer time. I'm not actually against it. I am against labels just passively participating in the royalties as opposed to being an active partner. So if we go back to the idea of an equitable partnership, if they take an active role in the artist's career, then a 360 deal is not as bad as what it may otherwise be if the label's active, if the terms are still constructed as they would be if you had 3 or 4 separate companies. I do think they should be structured as option deals where the label has the option to go into publishing or merch, and there are additional advances that would be tied to that and additional provisions for when these sorts of things can pick up. And perhaps also if the record recoups off of the record royalties and the other royalties are off the table in terms of recouping. So there are mechanical ways of structuring it. And again, the labels and artist lawyers would figure that part out. But I do think it needs to be adjusted. So number 3 was provide for the common defense. And we think of the U.S. Constitution, we're providing for defense of the states and not letting one state fall behind the others, whether it's from within or from without. And I think what the labels have to consider here is protecting the interest of artists, protecting artists' rights when they're negotiating, for example, streaming deals or deals with third parties, where very often the artists don't have a seat at the table and they just get whatever is left over for them out of the deal. So they're not at the table negotiating with Spotify or Universal, for example. And the labels need to have the artists in mind as a fiduciary matter and as having a fiduciary relationship to make sure that they're taking care of the artists. Again, we're talking about fostering trust. We're talking about fostering a long-term ecosystem that will work for both label and artists. It's not equitable to hear that labels' income is going up from streaming, but the artists are still making very little money off of streaming platforms. The label should also have an active participation in lobbying for initiatives that would generally help the artists, such as, for example, the American Music Fairness Act, designed at getting broadcasters to pay royalties toward labels and therefore the artists that are performing those songs. And the labels need to make it clear that we're not just here on behalf of the record label, but we're also here on behalf of the artists that we are partnered with. The number 4 provisions from the preamble says we're looking to promote the general welfare. And I think this is a really important thing that labels should consider. It's always been an important thing in the industry. And certainly now in this moment, having come through or still going through a pandemic, having come through 2 years of a pandemic in particular, I think it's really important that labels consider the welfare of artists and do things that they can and provide initiatives to help artists. So support artists' physical and mental health. Sony Music Publishing recently launched an initiative, the Songwriter Assistance Program. And I think labels should look to that to determine how can they help artists that are on their roster. So we don't have this system of, well, we can sign an artist, we can ride them until they go into some sort of a problem, and then they're on their own in terms of getting rehabilitation or help. There are various nonprofit organizations. I think Music Cares through the Recording Academy is such a wonderful organization that helps lots of artists that are in need. Labels should look to do very strong partnerships on behalf of their artists with agencies like that, but also provide their own resources. As we know, artists are not employees, so they don't typically get health benefits and insurance and these sorts of things. And I think it would go a long way for the labels to start considering a structure that would then look out for the artist's well-being. Labels should cease exploitation all exploitation tied to race, gender, power imbalance. We see from the USC Annenberg Inclusion Initiative recently, one on underrepresented populations in the industry and another specifically aimed at gender inequality. Inequality still exists at the highest levels in the music business, and it's unacceptable. I have no other word but unacceptable. And the labels need to take a proactive approach at finding ways to address that. Now, the expectation is, in my opinion, on both sides of the glass, right? From the executive side and who's in the boardroom making decisions, but also from artistic perspectives as well. Curbing, ceasing where they can, exploitive music. I get it. A lot of artists will say, well, no, this is the music that I want to put out. But the labels are in control of the budgets. The labels are in control of the agendas. And I think there's a point where they have to start to consider promoting the welfare of their artists, promoting the welfare of the business and its consumers and fans by adopting policies that are going to have a better balance of race, gender, when we're releasing music and music videos and this sort of thing. The number 5 concern is actually number 6. To form a more perfect union is the first one, but the 5th one that I'll talk about is secure the blessings for liberty. And here it's for both labels and the artists, but the blessings of liberty, freedom, right? Every artist wants this sort of artistic freedom. And I think the label should safeguard that. Now, the contracts provide that the label has approval. The label they'll go to the artist for some approvals. In the event of a disagreement, the label shall control. If it's a new artist, they get very little approval over content or maybe even the people they're working with. And the label should consider the artistic freedom. After all, the artist that you sign is someone that has been doing their own thing at the moment that you found them. And they like that. And they've been somewhat successful in most cases by the time the label gets around to signing this artist. They should safeguard that freedom and let the artist experiment, allow them to do what may speak to them and not necessarily let commerce control. Now, I get it. It's the music business, and there's a business side to it, and we do have to earn money. We have to earn income. But I don't know that we want to focus solely on the income where the artistic freedom gets stamped out, because, again, long term, that's not very sustainable. The label should get behind, as much as they can, direct fan engagement so the artist can go to the fan without filters. There should be, obviously, some controls, either from the artist management team or A&R team. But they should be behind direct fan engagement to allow the artist this organic connection, if you will. On the horizon, of course, are things like NFTs and micro-publishing. Artists are going to be more in tune to that, especially new artists that they start to sign that are younger, that have been out in the marketplace. They're going to be more in tune to that than the label execs in a lot of ways. And the labels need to get around this. And when I say get around it, get their arms around it. To a large degree, we saw the technology of MP3 come in and kind of just run amok in the industry before the record industry really understood what MP3 or file transfer protocol or these sorts of things were capable of. We want to be ahead of the wave on this one and embrace NFTs and find a way, again, in an equitable way to work with artists to develop them. And also to consider things like micro-publishing. Now, that's more of a publishing issue than a record label issue. But again, the idea is the artist can be crowdsourced by multiple fans. And I think labels, publishers should consider that when and where they can. It's going to be most likely a very democratized future because artists are going to have access to so many technological advances. And if the legal landscape starts to shift in their favor, I don't think you'll see fewer artists wanting to be on a major label because, again, the labels have such resources and deep pockets. But you will certainly see more artists saying, well, no, I can go without and do it on my own. And I think I don't want to say the death knell, but the real problem for the labels will be for the established artists that are on their labels. If they're not tied to contracts longer than 7 years, if they can get around re-record restrictions, if the master recordings don't belong to the label, you'll see far more Taylor Swifts and Frank Oceans and Kanye West, and you'll see a lot more artists challenging these terms. and going it their own way, because the playing field will start to level in their direction. So those are my recommendations. Those are the guiding principles, I would say. And I'd love to talk with you about your impressions. Thanks.